Hi, Rob from Raine&Horne. I'm here with Jonathan from Hozack Clisdell Lawyers. I'm here to speak about deceased estates and some frequently asked questions around that. How are you going?
Good, thanks, Rob.
That's good. So a client has been made an executor. What are the first steps around that?
Sure. Obviously, the first step is for an executor to arrange the funeral. It's obviously a very sensitive time for people. Once that has taken place and the executor's ready to do so, then their duty is to arrange a collection of the assets and settlement of any liabilities, and then distribution of the assets to the beneficiaries of the estate.
Can you explain what probate is and some timeframes around that?
Sure. Probate is proving a person's will. It's a formal process where a person's will is lodged with the Supreme Court for checking. If the court is satisfied that the will has been signed correctly, then it will issue a grant of probate. Generally speaking, it could take between 6 to 12 weeks to obtain a grant of probate.
Does probate need to be finalised before you market or sell a property?
No, it doesn't, is the easy answer. An executor can exchange contracts for sale of a property without probate being granted. However, the contract should have a special condition that completion of the sale is subject to obtaining a grant of probate and the property being transmitted into the executor's name. Then completion can take place shortly thereafter.
Can you explain the difference between an executor and a beneficiary?
Sure. An executor, quite simply, is responsible for administering a person's estate strictly in accordance with their will, and the beneficiaries are the persons who are named in the will and receive the benefit of that person's estate.
Do you have to use the same solicitor for the will and contract for sale, or can be separate?
No, there's no obligation to use the same firm acting for the estate to prepare a contract for sale. While it can be more convenient and practical, there's no obligation to do so.
So when is the estate distributed to the beneficiaries?
Sure. Usually after the assets have been collected and any liabilities have been repaid and settled, then the executors are in a position to distribute the estate, provided they're satisfied that there's no other persons that could potentially make a claim against the estate for greater provision.
And finally, what are the tax implications, including capital gains, on inherited properties?
Sure. If a deceased person treated the property as their principal place of residence, generally speaking, no capital gains tax will be payable on sale of the property, provided it's sold within a 2-year period from the person's date of death. If, however, property is treated as an investment or as investment property by the deceased, then capital gains tax implications can apply, and we always recommend an executor obtain taxation or accounting advice.
Thanks for answering those frequently asked questions.
You're welcome, Rob. Thank you.